Adam, thanks for joining us. Thanks for making the long walk down from Bloor and Islington to just across the river here. We've met, what was that, like grade 7, something? I don't know. Probably on the ice first and then at John G. Althouse, the fine junior school in Etobicoke.
You're at John G.
I remember meeting you at John G. I was like, I remember playing hockey against you.
Yes, it's been a while.
It has been a while.
You can't really date us just by saying the school, though.
No. And then on to the Great Collegiate Institute of Richview.
Yes.
Yeah.
5 years that I think I've repressed completely, and I don't think I remember anything.
I'm still scarred by being forced to try and reference stuff properly in English class and scientific journals. And if you put the comma or period in the wrong spot, it was plagiarism and your life was over.
Well,
That's what I remember.
I guess that's why you're a real estate agent.
Yeah, you're part of a family law practice here in Etobicoke, second generation.
Actually, this location, I'm a third generation.
Third generation, wow.
My grandfather, he started his practice in the late 50s. He practiced until the late 70s when he passed away. And then my father took over the practice in the late 70s, continued on until I joined my father in and around 2012. So I'm the third generation practicing in this office at Bloor and Islington, but actually fourth generation lawyer.
Oh, wow.
Yeah, my great-grandfather on my grandmother's side was also a lawyer.
Oh, that's amazing.
Yeah. And then who knows, maybe it ends with me.
Nice. I guess tell us a little bit more about the law practice. Is there something you get special in or you do a bit of everything?
So we are a pretty generalized practice. In terms of real estate, we're not fully devoted to real estate, but it does comprise, I'd say, approximately 30 to 35% of the practice.
Oh, wow.
Both residential and commercial, but mostly residential.
Yep.
We do quite a bit of corporate commercial work.
Okay.
So not just standard incorporation and corporate resolutions, but we also do transactions, so purchases and sales of businesses.
Yeah, mergers, acquisitions.
Yep. And that could comprise maybe another 30 to 35% of our practice. We also do civil litigation, tax litigation, and then we also have an estate practice. So the standard wills and powers of attorney, but also a bit of estate planning, and estate planning in particular in private business and private corporations and reorganizations from estate planning perspective.
The way it's been described to me for estates is if you have a business, if you're incorporated, you need to have the corporate will just as importantly as having the personal will for assets and everything.
That's right. Yeah. So there is that option as part of an estate plan. There are corporate reorganizations that can be done in order to alleviate other tax measures that arise when someone passes. But the corporate will or the secondary will is a will that is prepared solely deal with the shares in a private corporation. And the benefit of having that secondary will is that the value of those shares can be administered without them forming part of the estate value for the purposes of probate or the estate administration tax, which is payable in order to obtain the probate or the certificate of appointment. So if you have a private corporation that has a significant value to it in terms of the shares, having that secondary allow the value of those shares to pass effectively outside of the estate to the beneficiaries under that will.
But it's also, for both sides, if there's, we'll use property because this is a real estate podcast, but if there's property, both, say one's a commercial property that's held within the corporation, trying to liquidate that or even deal with the leases that might be in place, you have to have the ability to do that. And without the will, that can hold it up a bit. That happened to a client and it was a bit of a nightmare because of the process you have to go through to be able to do it.
Yes. So again, having the secondary will, the estate trustees named in the secondary will can immediately take steps to administer the secondary estate or the shares and deal with the assets, the underlying assets.
Estate planning in general is such a huge thing and becoming a bigger topic with an aging population, and just to make sure that your ducks in a row and that it can be taken care of, because if it's not, it can create some pretty major hurdles.
It can. And every estate is going to be different because the asset composition, the familial composition, siblings, step siblings, half siblings, all of those can take a toll in terms of the administration.
Families always play nice though, right?
Once the vultures start to circle, you never know what's going to happen.
Yeah.
So it's always best to get your ducks in a row, make sure that your estate plan is solid and that you can move on to
The
horizons,
the next chapter and move on. Yeah.
and ensure everything's in place.
Speaking of the next chapter, we'll jump into kind of a topic that's we're seeing a lot of coverage in the media right now is, I guess, title fraud, mortgage title fraud, that sort of thing. Basically, what we're seeing is it was reported is that an owner has their home and they've rented it out. And generally, they're not local. Sometimes they've gone somewhere else in the province or country or overseas. And while they're away, that property has been listed by another agent and sold to a third party using things like fake IDs and that sort of thing. And so they come back and it's like your property's gone and the new owners have no idea either. So one of the things when you're acquiring a property is title insurance. So can you give us the high level on what title insurance is?
Yes, title insurance does address a number of different potential issues that arise in property ownership. And one of them is title fraud. So there's also mortgage fraud.
Yeah.
And I think you described title fraud pretty accurately.
Okay.
Typically, the homeowner is not resident in the property.
Yeah.
It's either being rented out or it's vacant occasions. And some fraudster has somehow learned of this. They've been able to effectively appropriate the ID of the owners.
Fraudster. I like that. Is that a legal term?
It is, actually.
I like that. That's good.
Books. The fraudsters will effectively steal the identity of the homeowners. They will retain professionals. They'll retain a real estate agent to list the property for sale. If the property is sold, they'll then have to retain a lawyer in order to act on the sale. And then you'll have innocent purchasers coming in, buying the property from these fraudsters. And the true owner of the property has no idea that this has happened. Yeah. And in fact, we had a client contact us last year.
Yeah.
And they were resident in the UK, and they had exactly this circumstance happen to them with that they had here in Toronto. Now, what ended up happening when they first contacted us, I immediately suggested that they contact their title insurer and inquire as to whether or not the lawyer that acted when they purchased did obtain title insurance, in fact, have title insurance. They contacted their title insurer. The title insurer investigated the matter. I don't know the procedure, the steps that the title insurer goes through, but they have to do their due diligence to ensure that this was, in fact, a fraudulent transaction. It would have been pretty clear that it was in this circumstance. And then, from what I understand, the title insurance then to the innocent owners of the property, the true owners of the property, provided them an offer. You can either obtain title back of the house, or you can have the fair market value compensation for the property. Our clients ended up, the individuals ended up taking the value of the property at the time in which it was transferred to.
So that side of it covers the original owner of it. And I guess we talked about the buyers of it who are unaware of it too. Should that original owner say, no, I would like the property come back? Now, would the title insurance from their purchase compensate them for that? Or how does that work for the other side?
Assuming the purchaser has obtained title insurance, I don't know if the title insurers, both, because there are various title insurance providers. There aren't a large number. There's about 4 or 5 in total. There's a few. So it could be that they had the same title insurer. It could be that the purchaser did not have title insurance. But I'm assuming that the title insurer would have provided compensation to the purchasers if in this particular scenario, but not entirely sure.
You hear about the scenario and then you hear that the title insurance and then the parties are taken care of, but I never really knew what the outcome was on each one.
There is also a land title assurance fund, which is a provincially regulated fund that is put into place to compensate innocent parties in particular transactions. So I think as a last resort, there could have been recourse if these innocent purchasers weren't covered by title insurance. May have been able to look to that assurance fund, but I haven't had enough experience in that area to know exactly how that procedure would play out.
So when I started real estate about 10 years ago, one of the common questions I got, and it was in my early 30s and it was probably dealing with a lot of peers that arose then was, do I need title insurance? And my answer was always yes. But I haven't had that question posed to me in 7 years, 6 years. So is that something that you often get dealing in that portion of it?
Title insurance does remain optional on a purchase, not required. It may one day become a requirement that all purchasers obtain a title insurance policy. And I think that there are some jurisdictions, particularly in the US, that do require title insurance. And in fact, I think in Florida, lawyers don't even handle real estate transactions, it's title insurers.
Oh, okay.
But in terms of title insurance, as part of the purchaser's process, we always provide information on title insurance and explain what title insurance is, make it clear that it is an option, but that it is always in the purchaser's best interest to obtain a title insurance policy. Because when you look at the purchase of a new home, it's one of the largest purchases you're ever going to make in your life. And for that, a relatively small additional cost, you can protect that major investment for the entire duration of your ownership. Title insurance is a one-off cost.
Yeah.
You pay for it once at the beginning, and if you own that property for 30 years, you continue to have that same policy cover you for matters such as title fraud.
Yeah.
And we did talk about title fraud. There's also mortgage fraud.
Yeah.
There are occasions where, very similar to the title fraud, you have a fraudster come in, effectively steal your identity, obtain a mortgage approval based on the homeowner's information, retain a lawyer to act for the fraudster as well as the lending institution, and they'll attach a new mortgage on that property. The lawyer will release the mortgage proceeds to the fraudster, and the fraudster takes the funds. That also is a matter that can be prevented by having a title and insurance policy in place. I think a lot of viewers are probably thinking, what about the lawyers? Why are they letting this happen?
There's various steps in it. Initially, we have to check to make sure that check ID with the parties. If somebody's selling, we have to go into the land registry, ensure that it's the same person and the same ID. If there's discrepancies, figure out what it is. If there's multiple people on there, we have everybody sign off on it. And then once it gets to, if there's a mortgage involved, the mortgage people have to do their due diligence, checking it. And upon closing or leading up to closing, you guys, I imagine, have to do your due diligence as well.
That's right. Verification of identity is a large component of our practice.
Yeah.
When we're retained in order to act on a transaction, it's one of the first things we have to do is verify the ID of the client. Now, fortunately, we have a pretty good reoccurring clientele.
Yeah.
So we've dealt with our clients multiple times in the past. So
multiple generations, probably.
Yeah. So I've dealt with third generation clients and fourth generation clients even. But if we have a new client coming in that we don't know and is being sent to our office from some referral that we're not entirely familiar with, of course, we need to ensure that we're doing our due diligence to make sure that they are the person that they say they are.
Yeah.
This became a little bit more difficult over COVID because we weren't doing, or there was...
You weren't meeting face to face, right?
Meeting face to face.
Yeah. That's across 3 steps of this, right? Yeah. I had a client, we were on the selling side, and we had someone come through, and the buying agent told me, he said, listen, I've never met my clients. We've just done Zoom everything. And I'm going to go through and do the tour. And the first time I meet them is when we've secured a property conditionally, and we're going to go through together. But prior to putting in the offer, he has to go through the step, and the mortgage person has to go through the step. And then...
That's right. And so the requirement to verify ID before COVID was that you'd meet the client in person. They would have to bring in 2 pieces of identification, at least one with photo ID.
Yeah.
You would verify the authenticity of the identification, compare it with the individual, and ensure that they're the same person. When we were unable to meet in person, the Law Society loosened the ID verification process and allowed it to be done virtually.
Yeah.
And the way it would be done virtually is clients would typically send copies of the ID in advance. They'd scan it, hopefully a high quality scan or photo. We then obtain the copies of the ID that way. And then when we met with clients by Zoom or Microsoft Teams, they would then have to show us the ID so that we know it's an actual physical form, but it's still not holding the ID and seeing that, feeling it tangibly in your own hands. And I think that could have, for certain fraudsters, set off a light bulb and said, hey, this is going to be easier to manufacture.
Yeah.
And it'll be easier for me to verify my ID that way. And that could have led to a larger incidence or a greater incidence of these kinds of frauds.
I'd speculate too that improvements in technology, something that we use on a daily basis, it's called Canva. It's drag and drop Photoshop. So it's made the ability to do these fraudulent activities probably a lot easier for people versus when you're trying to create a fraudulent passport or driver's license. You have to make the physical component rather than just a digital image of it.
Yeah, that's right.
Yeah.
And now, because a lot of the COVID restrictions have eased and effectively they've effectively gone, there's no real reason not to meet clients in person. And the difficulty is a lot of clients, they have now developed a preference to meeting virtual because actually physically going to the location, physically going to the office can be a bit tedious, particularly in Toronto traffic.
Yeah, and it's, hey, can I DocuSign it or can I use Authenticide? If I digitally sign it, I don't physically have to turn the page and feel guilty about not reading it.
Yeah. So this virtual ID verification is still something that lawyers can do. The virtual ID verification was verify the ID of clients.
Okay.
Our practice, though, is if it's a client that we're not familiar with, we still stress the importance of coming in and meeting in person.
Nice. That makes sense. I didn't know it was extended to 2024.
Again, I think it's the transition back to the office.
It is.
For a lot of people, there's the hybrid now where they're working partly at home, partly at the office. And I think people have become very comfortable with Zoom meetings and Microsoft Teams meetings and doing things virtually because it's much more convenient. In fact, there's been changes in our own profession from the civil litigation standpoint that some appearances in court are now done through Zoom, which can be very convenient in some circumstances.
Interesting. Just going to throw it out there. Maybe the Landlord Tenancy Board here in Ontario should look at a way to expedite things, but that would be nice to see. So this type of fraudulent activity, whether it be on the mortgage side or we'll call it the title side, it's been around forever.
That's right.
People have been doing it. And so maybe there's a few things that made it a little bit easier for fraudsters to operate, but it's happening, but it's not being reported on. So it's very important to make sure you get the proper insurance.
That's right. Seeing it's more prevalent now because of the way in which our news is becoming 24/7. We're inundated with different topics from different newscasts. It's all on your phone. I don't know if the incidence of title fraud and mortgage fraud have actually increased through COVID. It would be interesting to contact a title insurer and find out.
It would be interesting to see the advancement of technology, how it probably created a barrier, and then at some point they realized, and it probably increased it. So I'm sure it waxes and wanes. Just to ballpark idea, is title insurance based on the price point of the home? So if you're buying a $500,000 condo versus $1 million or $2 million home, does it change or is it just a ballpark?
Yeah, it's pegged to the purchase price.
Okay.
So the higher the purchase price, the more expensive the policy. But if you think about the length of time that you're likely going to own a property, the increase in price is, I don't think, material.
Okay.
It does have a bit of a sticker shock sometimes because if you're purchasing a property for over $1 million and now you have to also add in a title insurance policy that's going to cost a couple thousand, you'd rather not pay that other couple $1,000. You don't feel like you have to. But if you're making a $1 million investment and you can securitize it for the entire duration of your ownership by paying an additional couple $1,000, it makes a lot of sense to do so. And actually, I think that might be one of the benefits of having this increased publicity of these title fraud scenarios, getting out there to the general public and they're understanding how important, how beneficial title insurance can be.
Yeah. So I had a client that title insurance came in very beneficial, and it was actually for an errors and omission. They had a condo townhouse that they had acquired, and when they went to sell it, it was discovered that the condo had allocated the wrong balcony or one component. I think it was the wrong rooftop patio to it in their plans. And so title insurance fixed it. But if they didn't have title insurance, then that probably would have held up the deal, or even it probably couldn't have closed. Yeah. So
moral of the story, get title insurance.
There you go. Riveting stuff about title insurance. 24-hour coverage. General question I have is advice for buyers and sellers.
Yeah, I mean, that's a tough one.
Let's go first-time buyer. So I think we covered the importance of title insurance. One of the advice I always give, and we alluded to a little bit, but if you're buying property, a tangible asset, is to make sure you have a will. And that's often something that I'm sure you present to your clients when they're getting a property, is to update their will or to get a will done.
Yes, actually. So when we receive a new client
Yeah.
or seller, we have a standard retainer letter that we send out to that client that sets out the relevant information that we need in order to close the transaction, information about our fees, information about the steps that we're going to take in order to close the transaction. And then we always end the retainer letter with confirmation that we can prepare powers of attorney and that we can provide further information as part of the process.
Okay.
So yes, it is, depending on the circumstances, a will and power of attorney can be very important to, in particular, when you're purchasing property.
Yeah.
But again, every individual circumstances are going to be different.
We'll continue advice for generally like first-time buyers here in the GTA. It's often going towards a condo. When you're purchasing a condo, there's one more step than a freehold home, and that's the review of status. So we obtain the status. If we get a deal done, it's usually conditional on the buyer's lawyer reviewing status. And the status certificate is when you buy a property in a condominium, you're buying your unit, but you're buying shares in a corporation. So you want to have an idea of, are there any lawsuits for or against that they're involved in? The big one is how much money are in the reserve funds. If the age of the building, are there any special assessments that are planned for major structural issues or replacing the elevators or something like that? A pretty hefty document that you get to read through. I've tried to read through them, and it's straight to sleep for me.
The status certificate is important because it's a snapshot of the health of the condominium corporation. Why that is a potential concern for a purchaser is if you have an unhealthy condominium corporation and you purchase a unit in the building and that condominium corporation doesn't have the funds available for certain expenditures moving forward, that condominium corporation can issue a special assessment on all of the unit holders.
Yeah.
And depending on what the expense is, it can be quite large.
Yeah.
And each of the unit holders have to pay their percentage interest of whatever that special assessment is. So when you're purchasing, the status certificate will set out some indicia of what may be a concern in terms of these potential special assessments moving forward. Now, generally, so condominium corporations are required to undertake a reserve fund study every 3 years.
Yeah.
That reserve fund study, you have professionals that go in, they'll review the building, they'll review the repairs, the replacements, and the overall.
They do an audit of everything.
They'll do an audit of everything, make some recommendations, they'll review the reserve fund to determine how much should be allocated to the reserve fund each year for the next few years. And generally, they're quite good at it when they conduct these audits. And so special assessments, usually when they come up, they're a bit of a surprise.
Yeah.
They're unexpected costs that the condominium corporation hasn't accounted for. So status certificates will indicate whether or not there's potential of a special assessment coming.
Yeah.
Now, if the condominium corporation knows that there's going to be a special assessment coming down the line, but
they have to disclose that.
They have to disclose it in the status certificate. And if they don't disclose that in the status certificate as a purchaser, if you obtain title insurance, will cover over that cost.
I didn't know that.
So that's also another benefit that title insurance can provide. Of course, you have to show it was a special assessment that the condominium corporation.
That it wasn't disclosed and that you were unaware of it.
Exactly.
Yeah. I go back to business school and got a certain way of thinking. And to me, it's the SWOT analysis. So strength, weaknesses, opportunities, and liabilities. And I'm really focused on to make sure that this business, this condo corporation, is in a position that's not going to give me undue liability in the form of a special assessment, or that they're wrapped into a lawsuit, or that there's something there that doesn't make sense.
Now, lawsuits are an interesting thing. We see, you'd be surprised how many condominium corporations are involved in lawsuits. The majority of them are slip and falls.
Okay.
And that is an insured liability. So a lot of the times, if there's a slip and fall claim, then the condominium corporation's insurer will cover that. And it generally won't result in there being a special assessment. Slip and fall lawsuits, I don't know why, but generally see the claim being $1 million. But typically, unless there is a significant wrongdoing on the part of the
Yeah.
condominium corporation, there's not a lot of concern with the slip and falls.
And that process can take a while, and it appears on the status certificate because they're obligated to notify you of that, even though in reality, the condo corporation has insurance that's going to take care of it. And to the owner, somebody might buy into a condo corporation while this lawsuit's going on, live there for a couple of years and then sell and still not be resolved.
That's right. And sometimes the condominium corporations are drawn into frivolous lawsuits
Yeah.
without merit. And the best way to really address that is if you are looking to purchase a condo and there is a legal proceedings that the condominium corporation is involved with, is to get a little bit more information from the property manager as to what that lawsuit's about, what are the potential liabilities that the condominium corporation is facing,
Yeah.
and whether or not this is something that's covered by the policy and being defended by the insurance lawyers.
Lots of moving parts when it comes to status certificates. For your process for the reviewing it, you have your process going through it, and you look and you say, okay, here are the items that stand out. Here's what you need to be aware of. And one is a very major concern. I have to tell you this. And if something like a lawsuit, you have to notify you of it, but this is how that's presented and what it really means to you.
That's right. And so when I review a status certificate, I have a standard report where I'll identify certain points and I'll send that to the client so that they can review it and they've got a written record, and always recommend that the client reviews the status certificate as well, even though it might not make any sense to them. But reading it with the report that we provide after reviewing is generally of some assistance.
And it's usually run away fast, or you're good.
Some buildings, yes.
Yeah, there's some buildings that, and it's generally the management company, or for whatever reason it happens. I find a lot of people like boutique buildings, but when you have only 6 units or 10 units, you still need to find a board of directors. And the smaller the pool, people's experience and knowledge of being on boards and running a business like that might not be there. There can be issues where I've seen maintenance fees go up 50% in a year, or even more.
Fewer the unit holders, the larger your percentage contribution is to the pot.
Absolutely, yeah.
And so if you have a small building and there's a major expense, then you're going to be paying a lot more than if you have 30 floors with 10 units on each floor.
Yeah.
Everybody's got their own preferences.
Yeah, absolutely. One of the things we start to see here is, I'll say, a triplex or a fourplex, or even an apartment with, say, 5 units in it, 6 units in it. People trying to turn those into condominiums. There's a benefit to that, but there's also liabilities you need to be aware of. And I think that highlights one of them. Okay, so the buying side, we talked about title insurance, we talked about wills, we talked about reviewing status for the status certificate on a condo. What about on a freehold property? Is there any advice that you pass on to, let's say first-time freehold buyers?
The majority of the time when I receive an agreement of purchase and sale, it's already signed. And at that point, the conditions are typically on financing and home inspection.
And when it comes from me, it's really clean, everything's done right.
Exactly.
It's presented to you in a nice package with a bow on it.
But from a legal standpoint, whether a purchaser likes a house or not, that doesn't matter to me. What matters to me is that the purchaser is receiving good and clean and free title. So there may be certain aesthetic items in a property.
Yeah, let's just go back to see what is good and clean free title. To me, that means that the taxes are paid on it and there's no liens against the property. Typically, we'll see a lien in the form of, if somebody's hired a contractor and there's been some dispute there, the contractor can actually put a lien on the asset on the property itself to ensure that they're essentially paid before a transaction can proceed.
Yeah. So part of that is done by the lawyer after the agreement of purchase and sale is signed.
Yeah.
So before the closing date, there's what's called a requisition date by which the lawyer will investigate title. We investigate the title by looking at an abstract of the ownership.
Is that what we call title search?
Title search, yes.
Yeah. Okay.
We do a title search of the
requisition
property.
date.
Yes. We will search the title of the property,
Yeah.
see what is registered against the title of that property. If there's anything that should be removed prior to the closing date, we then write to the seller's lawyer and we advise the lawyer that they'll have to remove these particular items. Some can be the construction liens, if there are any. Some can be just mortgages. There could be other expired
The biggest
covenants.
one that we see all the time is your furnace and your AC. When there's a plan on that's actually tied to the title of the property.
Yeah, they're financing hot water tanks or
Yeah.
mechanical AC units, HVAC, sometimes those entities will register a security agreement against title to the property. And the purchaser will typically, in the agreement of purchase and sale, agree to the rental agreement or the financing agreement. And that registration will stay on title unless there's an obligation for the seller to pay off, or to pay out, sorry, I should say, the cost of those units. And then at that time, there would be a requirement to discharge the registrations from title.
I don't know if you're aware of this. So Treb has added a field for us now on listings to list property items that are included, excluded, and rental items.
Yeah.
So before, we see it in the broker remarks that the public don't see it. And there's often information about if there's an offer date, the number of schedules to be attached, if there's a desired closing date, it's written in code. The rental items would also be listed in there too. So now it's a field, and I'm not sure if it's publicly viewed, but we can see it. They've separated it. So I don't know if they tell you guys that.
We just look at the agreement of purchase and sale and see what's registered on title. Now, it does become an issue on closing in circumstances where there's, in the agreement of purchase and sale, if it doesn't indicate that there are rental items, but it turns out that there are rental items, it can be a problem towards closing because there's an obligation then on the seller to pay out the remaining balance for those particular HVAC units.
This is where listing agents get in trouble.
Yes.
And I've been a purchaser of a property where the listing agent had to pay out, I think it was hot water tank, furnace, and AC, and I think it was about $15,000 because that information wasn't disclosed.
That's right.
And that's on our side, the messaging from the lawyer was that the contract doesn't detail that, so we expect that's free and clear by the time we close.
For any purchaser, when you're entering into the agreement of purchase and sale, you're not expected to know what's registered on title.
Yeah.
And it's really about ensuring that it's the house that you want. And I suppose the one piece of advice is to ensure that you can afford what you're buying.
Yes.
There have been instances in the past where someone has purchased a property and they're unable to close because their financing wasn't in order before they entered into the agreement of purchase and sale. And that, of course, is always going to be a big problem when you get to the closing line.
I think we were talking earlier, and I think something that we hit on was just the importance, and you mentioned even with the status certificate, is read the documents. Write down if you have questions, take the time to review it. If you feel like you're being forced to do something quickly, you got to be very careful, right? These are legally binding documents, and there are consequences with it. And ideally, that's that you get the home that you want with the conditions and terms that you want. But make sure that you receive a copy of it, that you have a chance to review it. We'll sit down with our clients beforehand, especially if it's their first time doing it, and send them a PDF of just what the blank forms look like. Go through it with them, let them know if there's any questions. Should be done also with the mortgage. If you're getting a mortgage or refinancing, making sure that's done properly and you have a chance to review the documents. And even when you're entering with a contractor or a company like yourself to close a property, make sure you're reviewing the documents.
Don't be afraid to ask questions. As a professional, Dave as a real estate agent, myself as a lawyer, we have an obligation to make sure that our clients know what it is that they're signing before they do, and that they're doing it freely and voluntarily. I was mentioning earlier that I had a circumstance in connection with a refinance where one of our clients was looking to refinance a second mortgage. A mortgage broker that she retained showed up at her doorstep, effectively telling her that she needs to refinance both the first and the second mortgage, presented her with a commitment letter, told her that she had to sign it right away. He only brought one copy. He effectively forced her into signing it. He then took that one page, the commitment away with him, submitted it directly to the lender right away.
Yeah.
When she contacted him a couple of hours later and said that she didn't feel comfortable with going ahead with the refinance in that way, the broker then responded, "It's too late. I've already submitted the documents to the lender."
Yeah.
The client then contacted me. We advised her to notify the broker that she's not proceeding with the refinance and the lender that they're not going to go ahead with it. It did cause an issue because she had signed a commitment.
Yeah.
And unfortunately, that would have been binding in normal circumstances on her. But because of the conduct of the broker, where there was effectively a duress upon her to sign the document, We related that information to the lender, and the lender understood at that point that the conduct of the broker was improper,
Yeah.
backed away, and chose to remove themselves from the transaction as well.
Glad to hear they did the right thing. Is there anything that a homeowner can do other than having title insurance to help deter their home being sold fraudulently from underneath them? One of the things that lenders often tell me they are pushing a product is to have, hey, you have a small mortgage on it or a line of credit, because that creates an extra layer of due diligence that has to be done with a bank. If it's with a major bank, it's probably going to be a little bit more strenuous than some of the other ones. Is that an additional step if there is something tied to it that you have to go through?
It could be.
Yeah, it's not guaranteed, but you're creating one extra hurdle for these fraudsters to go through.
Yeah. Now, in terms of discharge, so we talk about the different types of facilities. So if you have a line of credit that's registered on the property, if it's not carrying a balance, then obtaining a discharge of that is relatively easy.
Yeah.
You don't have to provide any identification. Simply what happens is the lawyer acting on the sale will request a payout statement.
Okay.
And in that case, it's really just the discharge registration fee, and then it's all handled behind the scenes by the lawyers.
Yep.
So having just a line of credit registered against the property without a balance doesn't really add any level of protection. Now, if there's an outstanding balance, this could alert the homeowner that something has gone off. If they're constantly paying down a mortgage or paying off interest on a line of credit on a month-to-month basis, and suddenly those payments aren't being processed anymore,
Yeah.
and they know that there's an outstanding balance, then the alarm bells will start going off. Did my mortgage come out this month? And then they might investigate at the bank, and if they find out that the facility had been paid out, then they're going to ask some serious questions.
Yeah.
So that is a potential, but again, it's a comfort level of whether or not you want to continue to have an outstanding balance on a loan facility with the bank. And given the interest rates nowadays, don't have to carry a principal. It's nice not to have one.
That's the goal, is to be mortgage free and own outright. But yeah, okay, good to know. I didn't know how quickly the line of credit was discharged if it had no balance.
So the process would be the same even with a mortgage. What happens is when you're acting on a sale, prior to the closing date, the lawyer will write to the bank and ask for a payout statement. The bank will, in most instances, without even notifying the homeowner, just send a payout statement to the lawyer. The lawyer will then pay out the outstanding balance as of the closing date directly to the bank, and then get their discharge. So a lot of that happens behind the scenes.
So one question I ask everyone who's been on is, if you've been in the industry for a while, you've seen some stuff. You've had some very interesting accounts or situations you've been in. For me, if I'm showing a rental property, it's a condo, I always knock and make sure that it's known that we're coming in, because if there's a tenant home, you never know what state you're going to find them in. I've walked into some homes and seen shag carpeting in washrooms. So there's every wide variety of things I've seen. Have you had any interesting stories or scenarios like that sort of come to mind?
I think most of my stories aren't going to be as excited because we're not dealing on the front lines.
Yeah.
We're dealing behind the scenes. I've seen a lot of messy titles.
Yeah.
And when you're acting as the selling lawyer, you hate to get a requisition letter where there is a private mortgage from 1950 that predates the ownership of your client by about 3 decades. And you do get those.
Oh, wow. And so that probably, the reality is that probably just wasn't discharged properly in a previous transaction.
Yes. And
how do you fix that?
So there is a procedure, and it's not a fun procedure. It used to be that you'd have to go and get an order.
The term procedure sounds a bit ominous.
Yes. Nowadays, the obligation is on the seller's lawyer to take all steps to locate the individual or the financial institution that's registered on title, to contact them to ensure that there isn't any balance outstanding, and to obtain a signed acknowledgement and direction to have that registration discharged from title. Yeah. But there are circumstances where that is a specific individual registered on a private mortgage from 1950.
Wow.
A lot of the times those people are deceased. And so I've come across this issue on a number of occasions. I've had to search obituaries to find this individual, to confirm that they've passed, try to locate their next of kin, try to show all of the steps that I've taken in order to locate this individual, and then put that in an affidavit form, submit it to the land registry office, and we apply to the land registry office and request that they discharge or they accept a discharge of that registration from title.
I had something similar happen to me. I bought a vehicle. It was a used vehicle. And when I went to go and trade it in to get a new one, the previous financing hadn't been discharged on it. So I had to jump through a bunch of hoops, contact the dealership. They said, hey, it was discharged on our end. It's the lender that didn't do it properly. So then I had to go and call the lender, wait on hold. And once I think I just showed them the agreement and they were able to do it, but it took several steps. These things happen and it's often innocent. Someone overlooked it and it doesn't come up. And it sounds like there can be other transactions where maybe some lawyers weren't as prudent and didn't catch it.
Yeah, no, that's definitely the case. And a lot of the times it's because there was a change from a paper registry format of conveyancing to land titles conveyancing, which is what we have now, which is all done electronically. And what the land registry office has done is taken each property has its own property identification number. It's got its own PIN. It's got its own legal description. It's taken all of the existing registrations on title and transferred it from the paper registry into the land titles. And I can only speculate that in certain occasions that checking the paper registry could have been a bit difficult back in the day.
Yeah.
And now we're very fortunate that we sign on to a computer. We can press a few buttons, get a full abstract or full title search of the property and see what's registered on the title and what's not registered on the title rather than flipping through pages.
Technology has changed the whole process.
That's right.
It's amazing. Great. I'm going to say thanks for coming on and joining us. You'll have to come back and we can dive deeper into the old process and adverse possession.
I appreciate you having me out.